Hello and welcome to a new episode of Legal Wrangle on indirect taxes. Today we bring you 6 cases relating to applicability of service tax on agency services, classification of items for customs tariff, service tax on reverse charge mechanism, applicability of the principle of unjust enrichment on a state enterprise, the constitutionality of Rule 10A of excise valuation rules, and the delicate distinction between manufacture and marketability for the purpose of excise levy. Our first case is a Supreme Court decision in the case of coal handlers, an assessee which provided services as an agent to Gujarat Ambuja Cement group of companies. The Apex Court considered the services provided by the assessee to decide whether these activities were covered under clearing and forwarding services and therefore liable to service tax under subsection 25 of section 65, which defines a clearing and forwarding agent. Let's get the details from Manip.
Sure, Asha. The Gujarat Ambuja Group needed coal to manufacture cement, which was allocated to it by the Ministry of Coal that identified the coal company which would provide the coal as well as fix the locations at which railway was to supply the coal. The Gujarat Ambuja Cement companies had therefore contracted the services of the assessee for liaising with the coal companies and the railways. The department held that these services were that of a clearing and forwarding agent and hence liable for service tax. Sestat dismissed the assessee's appeal by relying on its own decision in the case of Prabhat Zarda, in which it was held that the definition of clearing and forwarding agent was very wide and included any service, even a service provided indirectly.
The matter reached the Supreme Court, which considered that the full bench of the tribunal in the case of Larsen and Toubro had overruled the decision given in the case of Prabhat Zarda as relied on by the Sestat. The Supreme Court, considering the scope of the assessee's activities as an agent, held in favor of the assessee. Service tax demands were set aside. Let's see the details of the judgment.
The Supreme Court held that none of the activities undertaken by CNF agents are performed by the assessee. Assessee does not have custody of coal nor arranges transportation of coal as a forwarder. Assessee's primary job is to ensure coal required by Ambuja is loaded as per the schedule. Services rendered by the appellant would not qualify as CNF agent within the meaning of section 65(25).
Our next case is also a Supreme Court decision on classification of imported LCD, liquid crystal display, for the purpose of customs duty. The assessee is Secure Meters, which manufactures electricity meters and had imported a consignment of LCD modules or printed circuit boards from Hong Kong for use in electronic energy meters. Manith has the facts of the case for us.
Yes, I do, Asha. The assessee sought clearance of LCDs under chapter heading 9013.80, which describes the goods as the other devices, appliances and instruments, and claimed assessment at nil rate. The customs concluded that these goods were not simple liquid crystal but elastomeric LCD displays, which were a specific part of the electricity supply meter and hence were classifiable under chapter heading 9028.90 as part of the electric meters.
The matter reached the Supreme Court with the assessee insisting that as per Rule 3A, goods had to be classified in the heading which provided the most specific description and not under a heading where the item could be used as a part thereof. The Apex Court held in favor of the assessee. Let's have the details of the judgment.
Note 2 of the chapter notes to chapter 90 lays down general explanation. However, it also clarifies that this general rule would not apply for those parts which in themselves constitute article falling in any particular heading. LCD used in electricity supply meters are only parts thereof. Entry 9028 does not pertain to LCDs but gas, liquid, etc. and includes electricity supply meters as well. LCDs are specifically provided in tariff item 9013 and covered by other devices in 9013.80.
Our next case is a CESTAT decision in the matter of two companies, the Indian assessee John Deere Equipments and the USA-based company Deere Company. The Indian assessee manufactured agricultural tractors, components and repair service parts under a technical collaboration agreement with a foreign concern on payment of royalty and technical service fees. The question before the CESTAT related to payment of service tax on a reverse charge basis. Let's get the details from Manit.
The USA company had no office or permanent establishment in India. The revenue held that both the Indian company, John Deere Equipment, and the USA company, Deere & Company, were liable for payment of service tax under the category of consulting engineer service on reverse charge basis for the services rendered to the Indian company for the financial year 2003 and 4. Demands were confirmed in accordance with the service tax rules 21D4 along with the interest and penalty.
The CESTAT ruled in favor of the assessee, holding that the provisions of section 66A relating to reverse charge mechanism came on statute from April 2006 and hence were not applicable to the Indian assessee. Demand against the USA company was also set aside as the provisions of Finance Act 1994 would not apply to a foreign company. Let's see the order.
The CESTAT held that demand of service under reverse charge mechanism can only be with effect from April 18, 2006. Demand on Indian company not sustainable. Set aside. Provisions of Finance Act 1994 do not apply to entity not situated within India.
Our next case is an interesting decision by the Supreme Court of India on the delicate distinction between manufacture, marketability and saleability. The assessee company in this case was Servo-Med, which purchased syringes and needles in bulk from the open market, sterilized these disposable syringes and needles, packed each of these in a printed plastic pouch which was then sold to Hext Marion Russell, its pharmaceutical customer. Each pack of these one-time use syringe and needle bore the brand name of the purchaser, which is Hext. Let's have the details of the case from Manit.
Revenue concluded that the process of sterilization was an integral and inextricable part of the manufacturing process which brought about the transformation to make these products marketable. Revenue held that the excise duty was again leviable on these syringes and needles which had already borne excise duty at the time of manufacture as a result of the sterilization done by the assessee.
The matter reached the Supreme Court, which held in favor of the assessee after delving deeply into the principles of manufacture on application of processes. It concluded that each of the processes could lead to a change in the goods, but every change did not amount to manufacture. There had to be a transformation that brought into being something new and different. The court brought up an absurdity that if a surgical instrument was used 5 times a day, it could not be said that the same instrument had suffered a process which amounted to manufacture and therefore was liable for multiple payments of excise duty. Let's see the details of the decision.
The Supreme Court held that the disposable syringe and needle in question is a finished product in itself. The added process of sterilization made the product more convenient to use. It did not bring about a transformation of the articles into something new and different. Neither the connector nor the end use of the syringe and needle had changed post-sterilization.
In our next case, the assessee company is Sescott Sheet Metal Works. It is a wing of the Tamil Nadu state government and supplies its entire production to another state undertaking, which is exempt from payment of excise duty. Later, the assessee realized that it was entitled for exemption from duty in terms of notification 111/88 CE. The assessee claimed a refund of the duty paid. The question in this case was when revenue had accepted the assessee company as being state-owned, state-controlled and state-monitored, could it still conclude that the assessee is not a state as defined under the Constitution of India for the application of the principle of unjust enrichment? Manit has the case details for us.
The assessee had supplied its entire production of goods after due payment of duty to Tamil Nadu Civil Supplies Corporation, another state undertaking that used these goods in relation to the public distribution system. Later, when the assessee realized that it was entitled for exemption from duty in terms of Notification 111/88CE, it filed a claim for the refund of duty. A disclaimer certificate from the state corporation that it would not claim any duty refund was also submitted. Revenue denied the assessee's claim on the ground of unjust enrichment, holding that the assessee is not a state as defined under Article 12 of the Constitution of India and therefore not liable to claim refund. The tribunal too rejected the refund claim, holding that when the apex court in the case of Mafatlal Industries held that the doctrine of unjust enrichment would not apply to the state, it was referring to an institution which represented the people of the country and not a company like the assessee.
The assessee appealed before the Madras High Court, which held in favour of the assessee. Let's see what the High Court held.
The Madras High Court held that Department has accepted assessee as a state-funded, state-controlled and state-monitored organization instituted by a state undertaking. Principle of unjust enrichment will not only apply to assessee as it falls well within the definition of state as defined under Article 12 of the Constitution.
Our last case of this episode is a Bombay High Court decision in the case of various assessees which were basically job workers for car manufacturers. These assessees, led by Highwa India, manufactured vehicle bodies on the motor vehicle chassis supplied by various chassis manufacturers like Tata Motors. The court considered the question whether Rule 10A of the valuation rules does not fall foul of the mandate of Articles 14 and 19 of the Constitution or travels beyond Sections 3 and 4 of the Central Excise Act. Was Rule 10A unconstitutional? Let's turn to Manit for the details.
The assessees had discharged central excise liability on their activity termed as manufacture of motor vehicles. However, effective April 2007, as per the new valuation Rule 10A, the assessees were required to pay duty on the price at which chassis manufacturers like Tata Motors sold the vehicle to their buyers. The assessees challenged the Rule 10A.
The High Court held in favour of revenue, holding that there was nothing unconstitutional, invalid or illegal about Rule 10A. Let's see the details of the order.
The High Court held that Rule 10A was introduced as preceding Rules 4 to 10, did not cover the job worker for the principal manufacturer. Rule 10A is not unconstitutional. It does not restrict fundamental right to carry on the business of manufacture of goods. Any standard which maintains a nexus with the essential character of the levy can be regarded as a valid basis for assessing the measure of the levy.
This brings us to an end of this episode of Legal Wrangle on Indirect Taxes. Thank you for staying with us and hope you enjoyed it. Remember, you can email us your comments, counsel and criticism at editor@tiol.in. Don't forget to subscribe to TIOL Tube on YouTube. It's free and it will keep you updated. See you again next week. Have a good day.